Well, I became involved really purely by accident. I was doing law and arts at Melbourne University and didn't have a clear idea of what I wanted to do. I had engaged to do articles at the end of my course, but and this was in 1970, December 1970. I took a vacation job doing research for the Hospital Employees Federation, which was a fairly large union representing mainly orderlies and nursing aides and other manual staff working in the health system. And I worked there doing a particular research project and became interested in the field and was eventually offered a position there, and I decided not to do articles but to stay there, which I did for 12 months. But for somebody with legal training, there was a limited scope there to do interesting work because I really wanted to do research and advocacy type work.
Well, when I was at the law school at the University of Sydney, I did a Master of Laws degree, and one of the segments I did in that was taught by Professor Thompson, and it was on industrial relations and labour law. In my daily practice at that time, I didn't really do any such work as a young solicitor, but then a number of opportunities arose for me to get work in industrial relations in New South Wales, and I must admit I wasn't very keen to do it, and as it happened I couldn't do the cases because though I was at the bar by this stage, I was always too busy. But one day a case arose in the New South Wales Industrial Commission before Justice Shepherd, who later became a judge of the Federal Court, and it concerned the Teachers Federation. Now, the Teachers Federation were very, very difficult clients, and they had successively sacked Lionel Murphy, Jack Sweeney, Bill Fisher, Jim Staples and several others, and so they turned up at my door. They asked me to take the brief, I took it, and I loved it, and after that I looked for other opportunities to get into the industrial relations sphere.
Well, it was an area that I was interested in. As a critic of the system, critic of many of the decisions that were made, and here was an opportunity to go into it and maybe to change things a little in the way that I thought was appropriate. I was anxious to change the absence of more rigorous economic analysis and decisions. I was anxious to speed up proceedings. I was anxious for material to be put into writing rather than everything to be heard.
It's difficult for people of today's age to realise that the old commission was a tremendously prestigious and very powerful body, and my own position at the time was that the membership of it was an aspiration that I didn't think would come my way. The commission was very much modelled on a court, and the presidential members were all Mr. Justice. There were no women members. Some of them had been members of the old Conciliation and Arbitration Court before the Boilermakers case. Sir Richard Kirby was the president. They had knighthoods. They were very long in service. They were very distinguished. They looked very venerable, and their names were on the ABC News, radio news every night, settling national disputes, fixing up strikes, fixing the basic wage, battling away about margins and questions of this kind. So that to aspire to be a member of the commission or the court was a very high aspiration, and I was a very, very modest young barrister, and that didn't really enter my thinking.
Well, I think everybody who's a barrister for long enough feels that at some stage they'd like to be making the decisions rather than accepting decisions from people who keep making the wrong ones. And So I suppose there's a time in everybody's life as a barrister when they feel they'd like to be a judge or a judicial figure making the decisions. It's almost the part of the process of being involved in as a full-time professional advocate that you would your career would take you in that direction. So yes, there were particular times when I very much would have liked to be making the decisions.
The most significant one was the abolition of the basic wage, I would think, and the establishment of a minimum wage. The basic wage goes 100 years old this year. In 1907 it was established. It was the harvester wage. It became the standard basic wage. But one of the interesting sidelines of that for me, and a personal experience, was while these proceedings were on, Casey was Governor General, Lord Casey, and I got a request to go and visit His Excellency up at his office in 4 Treasury Place. And when I got in there, he said to me, well, I just can't understand anybody of your background and your upbringing seeking to destroy something like the basic wage. Here's this arch conservative. And so I explained that we were not trying to destroy a basic wage. What we were trying to do was establish a proper basic wage. So we had a long discussion, and he accepted that. He said, well, I think you should go away and do a lot more work on persuading people about what you're trying to do, because nobody really understands it. And then he gave me a lecture on the life cycle of a prawn, having just come back from the Northern Territory.
Yes,
No, that
didn't
changed. That changed
women weren't in
dramatically.
the industrial.
No.
You see, I was just mentioning before we started this conversation that when we started in 1975, I can remember that there were 2 women who used to appear before me in the industries that I dealt with, and one was Anna Stewart, who was for the Vehicle Builders Union, and the other one, I can't remember her name, but she appeared for the Master Builders Association, and they were the only 2 women who ever appeared before me. But gradually, more and more women started popping up at the bar table, both for the employers and the unions. And when I left in 1991, when I retired, and one of the last cases I presided over was the parental leave case, and there were days when the whole bar table was female, and it was a big bar table. All the state governments represented, all the major interest parties represented, and mainly by female advocates. And that had changed in that period.
Was there an expectation that you would be interested in women's issues, being women?
Not within
really.
the Commission, ever. And not, I think, among the parties. Sometimes in the outside world.
Yes.
I remember having at a dinner once with a man who was an executive of one of the large manufacturing companies, and I'd known him through my previous, personnel and industrial relations days. And he'd said, "Oh, you look well, and you seem to be enjoying your job very much." And I said, "Yes, I am indeed." And he said, "Well, I suppose you'd be dealing with the women's issues." Well, at that particular time, I was right down in the depths of the maritime industry, having awful problems about the 2-shift system. And I said, "Well, there are not very many women actually who are really on the crews of ships, and that's what I'm dealing with at the moment." "Oh," he said. So that sort of societal expectation didn't change till later.
One of my areas was in the garbage collecting industry, and I'd had the garbos in large numbers from time to time. But they were all very well behaved. I'd never had any problems. The only problem we ever had was with a group of women. At the time when we were dealing with this is late in 74, yes. We were dealing with the question of whether there should be the same minimum wage for males and females. And I'm not sure what the group was, but they were established on this campus. And they came in their numbers. There was a full bench. Mary Gordon was representing the Commonwealth. And they began to catcall from the floor, and John Moore said, "Well, there, please keep quiet. We couldn't proceed on this basis." And so they, in their numbers, I think there were about 20 of them, proceeded to march on the bench. And at that point we adjourned, and our associates tried to grapple with them. And they got as far as the bench and poured water all over the bench. We had meanwhile they called cowards, cowards.
The pilots were seeking an increase, I've forgotten the exact figure, but it may have been in the 20% range, perhaps more. And at that time there was a centralised system of wage fixation operating, in which the only increases that were received at award level were through the national wage decisions. There was, and that system had been operating for some time and had been very successful in containing wage increases in Australia during a period of reasonably high inflation. But in any event, the pilots decided they wanted to break out of that system, and they imposed 9 to 5 work bans, which of course were going to have a very dramatic effect on airline schedules. The airlines decided that they would stand aside under the common law of contract any pilot that imposed those bans, and almost without notice the pilots resigned as a group. Well, the airlines, as now part of history, decided to hold firm, and with government support they advertised for pilots everywhere in the world. But over a period of 6 months or more, the airlines gradually built up their services through recruiting new pilots, and a very, very bitter war developed between the new pilots and the pilots who'd resigned. The great tragedy of it was that having resigned, the pilots had absolutely no rights under industrial or common law, and many of them never worked in Australia again. Many worked as pilots for overseas airlines and lived out of the country for the rest of their working lives. But in the end, the government and the airlines were successful in maintaining the centralised system. But you can still hear American voices on some of the Australian Qantas aircraft, as you know.